Keep eating.
Is the mic going to go automatically on the one you do? She said it's not going to be live until it starts. So
She'll wait as soon as I. Welcome to this year's last in the speaker series. It's jointly sponsored by the Duke Journal of Constitutional Law and Public Policy and the Program in Public Law. Before we start, since this is our last event in the series this year, I want to thank everyone who's made this series possible. Professor Chris Schrader has been our sponsor this year, and he's been really helpful in putting this all together. Dana Norvell has played a huge role in getting all the logistics done for each of our speakers this year. And my co-chair for the speakers, Julian Yap, as well as the members of the Common Law Journal who have attended all of these events well and have really put the interest out there so that we can keep inviting really exciting speakers. Today's speaker is a distinguished public servant and a source of inspiration for those of us who aspire to careers in appellate litigation. Susan Boleyn is the Senior Assistant Attorney General of the state of Georgia, and she graduated from LaGrange College before going to the University of Georgia Law School. She joined the State Attorney General's office in 1976. Since that time, sorry, I'm not trying to age you, Susan, but
thank you.
Since that time, Susan has argued more than 100 homicide cases before the Georgia Supreme Court, 100 capital habeas cases before the 11th Circuit, and 4 death penalty cases before the United States Supreme Court, although I found out last night that she was actually second chair in even more cases in the Supreme Court. She's a frequent lecturer in high schools and colleges across Georgia, and she's testified before the United States House of Representatives Judiciary Committee and Subcommittee on Civil and Constitutional Rights. We look forward to hearing about Susan's career in public service, and we welcome her to Duke Law today.
Thank y'all so much for having me. I hope it's going to be okay to be entertaining at lunchtime. I don't know about informative, but at least maybe entertaining while you eat lunch. And I have to really brag on myself because this is the first time I've ever used a jump drive, and I am very impressed with myself since I learned to type on a manual typewriter, so this is a big jump for me technology-wise. I'm going to let Sarah keep me okay on time, but if there's some burning question that you have in the middle of it, please feel free to stop me and ask a question, and hopefully it'll be entertaining and informative. At least that's my goal. And if I mess up the PowerPoint, I'll have to call for one of y'all to help me get started. But it's really indeed my pleasure to be here at Duke Law School and to have Sarah invite me, who's the daughter of 2 of my former law school and undergraduate classmates. And it's just a delight to be here and talk a little bit about my unexpected career in public service. And I hope you let me kind of tell you how I got there, because as I was telling Sarah last night, nobody who ever knew me in law school would think that I would ever argue any case before any court, much less the United States Supreme Court. Because my last name is Boleyn, people always think it's a little bit ironic that Anne Boleyn is supposedly my ancestor, and of course she was a person who received capital punishment at the hand of the king. And so because I do capital punishment, it's a little bit ironic that I'm supposedly descended from Queen Anne Boleyn. And I love this quote from the book, The Other Boleyn Girls. Says, "Why do you think George declares that Anne's the only Boleyn anyone will ever know or remember?" So I guess Anne Boleyn and Susan Boleyn are going to be known in a similar vein because of capital punishment. I ran across this quote by a Georgia Bar Association member, and it's something that I really like, is that we who practice law may enjoy it. I think that when I was in law school, I didn't think you could enjoy practicing law, but I think that one of the wonderful things about law is that it's just so much fun, especially when you get to do the kind of things that I get to do and have the experiences that I'm going to describe for you. I ran across, that's Justice Scalia with his head cut off up there at the top, and I ran across a wonderful quote from him. He said the law doesn't have to be dull, and that he thinks that he and Justice Thomas are the only 2 original people left, but that he's hoping that law students might pick up the mantle because he thinks it's, lawyers are a lost cause, that nothing's going to happen about being an original person. He certainly is an original. Now, I don't know what outfit I had on, Scotty, in LaGrange College, but I grew up in Athens. I was born in Atlanta. And of course, I don't think in the second grade there that I ever had any idea I was going to argue before the United States Supreme Court. And then one of my law school classmates that was also an undergrad with me at LaGrange College took this picture of me, and what you can't see in the background is I'm behind my cemetery. So that's the cemetery. So I don't know if that was prophetic or not. All right. I can't remember what that says at the top, but I think what it says is that I became the meanest woman in the state of Georgia. That's what the Attorney General of Georgia called me, the meanest woman in the state of Georgia. And I came in 1976. When my mother saw this picture of me in the newspaper, she said, "Is that you?" She said, "You don't look very happy." I said, "Well, do you think you should smile about fixing to execute people? I don't think that would be very appropriate." So you'll see some hairstyles over the years as I go through this. There was two other women, Paula Smith on the far left, myself in the middle, and then Mary Beth Westmoreland. We were the first three women in the criminal division of the state law department in Georgia, and our boss called us death, famine, and pestilence. Well, I don't want to be pestilence. I don't mind being death and famine, but I don't want to be pestilence. And they came out with a newspaper article about us and said that we don't fit the mold, that we're hardly the biggest, meanest, baddest lawyers around. And that's in 1986. See, again, I was doing my stern prosecutor look up there in the picture. I thought it was kind of interesting that what this article said, that few law firms need a resident death penalty expert, but that each of us has weathered criticism from capital punishment foes who fail to distinguish the advocate from the cause. And what I was trying to tell people is that I didn't come into thinking, well, gee, I believe I'll do some death penalty cases. I came into the law department, I was assigned to the criminal division, and as you'll see, timing is everything, and I came at the right time and got immersed in capital litigation, and I think of myself as a constitutional lawyer and as an appellate lawyer. Like many of you in law school, I think that I had mixed feelings about the death penalty. And I think what surprises a lot of people is I continue to have mixed feelings about the death penalty. And I said, if I don't have mixed feelings, I probably should not do the job that I do. I need to maintain some objectivity and some ability to distinguish among the cases. And here's death, famine, and pestilence 30 years later before the United States Supreme Court. This is Paula Smith in the middle. She just argued the Randolph case on search and seizure, whether the wife can consent in the absence of her husband's consent for the search of the premises. So I was, I guess, third chair on that case. Again, this is from that same article talking about that all three of us were in our early 30s at the time, so you don't have to age me, Sarah, I'm doing it myself. All of us were graduates of Southern law schools and from small Georgia towns, and that one of the things that it's done is it's offered the rare chance to shape legal precedent on crucial criminal law issues. And I've listed at the bottom just some of the many cases that we've done. Between the three of us, we've done 14 arguments in the United States Supreme Court, and we've been second chair. I've been second chair on 15 other death penalty cases. So who knew, as we said, that this is what we would end up doing? I'm going to skip this because it's a little bit long, but I played it for everybody at the law department. And what it is, you know, the reputation that's good enough for government work. This is a thing you may have seen it on the internet, in which two government attorneys, we're going to call them, get stuck on an escalator and they can't figure out how to get off the escalator. So that they call for help. And timing is everything. This article from the AJC from 1996 talks about, for decades, that Georgia has set the standards for executions nationwide, possibly more than any other state. And I came to the law department in 1976, right after Gregg versus Georgia had come out, validating Georgia's death penalty statute. So I was able to be a part of every death penalty case that came along in Georgia, and there's many of them, as you're going to see in the next one. Of course, in 1972, in Famine versus Georgia, they ruled that the death penalty was unconstitutional. And then, of course, Georgia was part of a trilogy of death penalty cases which found that as long as the jurors had discretion about whether they should impose the death penalty, and it was not a mandatory death penalty, that these constitutional schemes passed muster. Furman, we talked about Gregg. Davis versus Georgia talked about you have to be unmistakably clear that you will not automatically vote against the death penalty. That's Curfew Davis. I was second chair on that. Coker versus Georgia, the death penalty cannot be given for rape if the victim is not murdered. I was about fourth chair on that one. Interestingly enough, lately they've talked about revisiting this issue now that we have women on the United States Supreme Court. They wonder if there would be a different result, if rape would be seen as being less than murder in the right situation. But in that particular instance, of course, you cannot get the death penalty for rape. Now, interestingly enough, in Georgia, you can get the death penalty for kidnapping with bodily injury if the victim dies. So we have the death penalty for offenses other than murder, but you have to have the death of the victim in order to obtain the death penalty. Presnell versus Georgia, that the jury must find there's legally valid aggravating circumstances. Virgil Presnell was resentenced to death, and he has a website. You can visit it. He is a child molester. He read a children's book while he watched children walk home from school, and he kidnapped 2 little girls and raped both of them and murdered one of them. Green versus Georgia, probably one of the most famous Georgia death penalty cases. I was second chair in that, talking about the nature of the hearsay testimony during the sentencing phase of a death penalty case. Godfrey v. Georgia, I was second chair. This is about the death penalty. We call it the 7th statutory aggravating circumstance, that the murder was committed with torture, depravity of mind, or an aggravated battery to the victim. One of the issues in Godfrey was the fact that all murders are aggravated of some form or another, because all murders, of course, have an aggravated battery involved in them. The United States Supreme Court was concerned about how you differentiated what a so-called regular murder from a death penalty case. Zant v. Stevens, I was second chair. Francis v. Franklin, Amedeo v. Zant, we're going to talk about those where I argued them. McCleskey v. Zant was there twice. I was second chair. That's the statistical challenge to the death penalty as being racially motivated in Georgia. Very controversial, and of course that was one of the statistical challenges. They selected Georgia because they could get our data readily, and they were going to use that as their flagship opinion to challenge the imposition of the death penalty using statistical analysis. They used law students to take various fact patterns from the different death penalty cases and quantify, for example, was a case bloody? And one of the reasons that statistics were found to be inaccurate or misleading was the fact that what you might think is bloody and what I might think is bloody and what the person on the street might think of as bloody might be a different thing. So one of the things that the Supreme Court said in McCleskey was that the various factors that are utilized by jurors in determining whether the death penalty can be imposed are too varied and too many to be quantified. Dobbs versus Zant, Burden versus Zant, Lone Star, all of these were, I was second chair. Now, we love our butts is the slogan of the county commission in Butts County. They actually had a big sign that says we love our butts. And so whenever I would go down to Butts County, which is the venue for death row in Georgia, because that's Jackson, Georgia, and it's the venue for our state post-conviction, my mother would say, "Are you going to We Love Our Butts today?" And I would say, "Yes, that I'm going to We Love Our Butts." We had a death penalty hearing, and the warden at the time that we had this hearing, he had seen the movie A Time to Kill. And so we had shotgun guards all around in helicopters, and I said, I feel like I was in a movie set because it does look kind of like an old-time southern courthouse, but it's quite interesting. And that's actually inside the courthouse. It's got stained glass windows. You feel a little bit like you're in church. The Georgia Supreme Court, as Sarah said, I've argued over 60 murder and habeas appeals before the Georgia Supreme Court. They have an interesting Latin slogan before the Georgia Supreme Court, Fiat Justitia Ruat Caelum, let justice be done, though the heavens may fall. So that's only 2 floors above me, but I've been arguing quite a lot before the Georgia Supreme Court. One of the cases that I argued recently, I guess 2000's recent for me, in the Georgia Supreme Court involved the validity of electrocution. Georgia is one of the few remaining states that had the electric chair. That's actually the old chair. There were 2 chairs, and that's the original electric chair in Georgia up there on the left that's kind of cut off. And the legislature of Georgia enacted a bill that said we will continue to have our method of execution as electric chair until a higher court tells us that it's unconstitutional. So we went before the Georgia Supreme Court. Well, I was doing my research and looking at autopsy photos of the people that had been executed in Georgia with the electric chair. And I went to the Attorney General and I said, you realize, of course, that constitutionally speaking, it's okay if it hurts. But I don't think you want me to argue that before the Georgia Supreme Court. I don't think we want a quote that says the Georgia Attorney General's office doesn't care if electrocutions hurt. So it was a very, very difficult thing because, of course, anybody who can look at that chair and doesn't think it looks a little bit medieval would be a very difficult person to deal with. So one of the things that I had to say, they had taken a poll of the Georgia citizens, and over 90% of the citizens believe that we should continue to have the electric chair under the theory that the electric chair is more scary than the needle, and that it actually might have some sort of deterrent effect. So what I ended up having to argue was the will of the people has been spoken through the legislature, and so we should continue to have the electric chair. During this argument, I got into a major fight with the Chief Justice of the Georgia Supreme Court because I told him that really this was not a fight about the method of execution, this was a fight about whether we should have the death penalty. And he said, no, it's not. I can't believe, counsel, that you are arguing that. And of course, that was the big headline, was that this is just a veiled, slightly veiled attempt to try to undermine the death penalty and not the method of execution. So we got into it during the hearing. And then Steve Wright, who many of you may know, he's a professor at Yale and also the head of the Southern Poverty Law Center. He argued that it was excruciating, painful, and unconstitutional, and this quote says that I said it does not cause pain and is legally acceptable. So, of course, I argued this, and my mother was in the hospital, and she said to me, you know you're going to lose, don't you? I said, well, thanks a lot for the support. And so we did lose. We did lose, and so then there should have been another one. Let's see. I guess I left that slide up. So we did lose. We lost 5-4, and the woman, Justice, wrote the opinion, and she was almost lost her bid for re-election to the Georgia Supreme Court because of her decision to outlaw electrocution. The first case under Georgia's death penalty statute was John Eldon Smith, a.k.a. Tony Machete. John Eldon Smith and his wife, Rebecca, conspired to kill Rebecca's previous husband and his new wife. They killed him to death in a rural area outside Macon. And one of the things that's really interesting is that he filed a jury challenge that was defaulted, because under Georgia law you have to challenge the jury prior to indictment, and he did not do that. And so we litigated his defaulted jury challenge all the way, and he ultimately was executed. Well, his wife, Rebecca Machete, she filed a timely jury challenge. And so the 11th Circuit set aside her conviction based on her timely filed jury challenge. And she was the only woman on death row at the time. So then one day, as I told Sarah last night, I was sitting in my office and I got a phone call, and my secretary said, it's Caroline Kennedy. I said, oh, yeah, right, sure. And they said, no, it's Caroline Kennedy. I said, oh, yeah, right. And so Caroline Kennedy was writing a book along with her law school classmate, Ellen Lieberman, and they were talking about different constitutional amendments. And they were talking about the right to an impartial jury. And so she wanted to spotlight the cases of Tony and Rebecca Machete because, of course, this is an interesting thing where one person has defaulted the challenge and one person hasn't. So we were just kind of shooting the breeze on the phone one day, and so she asked me what I thought about it. And this is from the book, and I said, they said, but from the vantage point of Susan Boleyn, John Eldon Smith's execution after 8 years on death row and 2 trips to the habeas corpus was not unjust. The injustice of it was that Rebecca didn't get the death penalty. So I didn't really know that was going to be the quote, but apparently she thought that was pretty quotable. And so that was in there, and she sent me a complimentary copy of the book. But Rebecca Machete was quite an interesting person. She threatened to kill me. We happened to be, this is with women attorneys now, we were in the restroom at the same time as a woman on death row, so she threatened to kill me in the restroom in the Milledgeville courthouse. The other big case that I argued before the Georgia Supreme Court is Georgia has a new post-conviction DNA statute, which I'm very happy that they have it, which allows a person who did not have DNA evidence available to him at the time of the original trial to get DNA testing if they can show a reasonable probability that such testing would impact the verdict in their case. And so the Georgia Supreme Court upheld the validity. In the case that I was arguing, the question was whether you were entitled to a hearing, and the Georgia Supreme Court said you were not automatically entitled to a hearing, but they upheld the validity of the statute. Now, if you can see up there, it says PBS, very lively death penalty debate. So this is one of my real claims to fame, as I was on firing line with William F. Buckley. Apparently, this was in 1994, and apparently they keep playing it on some, stations throughout the country, like at 2 o'clock in the morning, because I'll get people to call me and say, Susan, I was just channel flipping, and I saw this thing, it looked like it was you, about the death penalty. And so I think if you could see that picture, I'm kind of to the left, but that's, I think, Ed Koch up there. And then, so it was on a pretty prestigious panel with Ira Glasser, the executive director of the ACLU, president of Bear College, Steve Bright, Brian Stevenson, and then on my side, the good side, was Walter Burns and Ed Koch and William F. Buckley. I tell everybody, I tried to get a clip so that you could see us walking down these stairs in really high heels. For me, can't speak for the gentleman. And we were walking down, and I was afraid I was going to fall when I got down there at the bottom. And William F. Buckley had all of his people to help him with his makeup and his appearance. And when I sat down, it's like if I were sitting in that picture, that's not me, but if he were sitting up, and I looked over, and his whole fly was open. And I looked like this, and I looked back this way. And my mother said, well, why didn't you say something to him? I said, what was I going to say? Barn door open, snowing down south? I mean, what was I going to say to the man? I said, plus I'm at eye level, so he's probably going to wonder why I was looking at his zipper. So anyway, it was quite an interesting debate. And Steve Bright and I got into it and just started screaming at each other, which I think made for good television. It was, arresting television. The other thing that happened was that I argued this case in 1981 of Willie Fred Beatty. It was a guy that had murdered 2 people, and he was alleging a conflict of interest between his attorney. His attorney had represented one of the other parties in the case. So I won in the lower court, and then Grace Lewis, who's next to me in the picture, she won in the higher court, and he got out, and it's about a month after he got out, he killed 2 other people. But as a result of that, I met Grace, and now she's my best friend, and I recruited her to come to the law department. So she beat me, but I made her come work for the law department. Now, I'm a dog lover, as you can see. My 3 dogs, I thought, well, I'll just throw them in there. Scout, Girly Girl. And this is the big Herschel over here, the 212-pound bull mastiff that has just gotten out of the vet school at Georgia. And so every dog has their day, and I had my Supreme Court arguments. So I'm going to talk about those a little bit. This is supposed to actually say, oh yay, oh yay, oh yay, which I didn't know that you can either say that it's French or Latin. And this is where I talk about the imposter syndrome. That little girl with the top knot I showed you at the first, that's kind of the way I felt when I went to the United States Supreme Court the first time. I thought, what the heck is a little girl from Athens, Georgia, doing arguing before the United States Supreme Court? But I said the first time was incredible, the second time was a pain, and the third and fourth time had their moments. But we had a tradition in our office that everybody sends you a telegram, good luck telegram, so that was my good luck telegram. And then I found this cartoon that I loved. It says 3 times as many Americans can name all three stooges as can name any 3 Supreme Court justices. And of course, when we go up to the United States Supreme Court, they have their names printed out for you on a card so you don't call them by the wrong name. Of course, all the smart alecks in my office says, well, there's more than 3 stooges. There's more. Weren't there those other 2 stooges? I said, okay. Yes, there were more than 3 stooges. First case I argued was Francis v. Franklin. This is Mr. Franklin. And the issue was whether the pattern charge on presumed intent was unconstitutionally burden shifting. A person is presumed to intend the natural and probable consequences of their acts. So that was the charge under Georgia law. It was a pattern charge. So, because I lost, 100, maybe 150 cases got reversed, no pressure. So I argued it, there you go, good hairstyles of the 80s. November 28, 1984. What happened was he was a prisoner in the Cobb County Jail in Marietta, Georgia. He was taken to the dentist. He escaped from the dentist. He went to a nearby house, knocked on the door. An older man opened the door, and Raymond Lee Franklin said, "Give me your keys or I'll shoot you." Not those words. And the guy slammed the door. So one of the big issues in the case was whether when he shot and killed the man, if he killed him like bang, bang, or if he killed him because when the door slammed, it made his gun hand go up like this and shot him. So again, you know, when you're explaining what you're going to be arguing in the United States Supreme Court, I said, well, really, the question is, was it bang, bang, or was it bang, bang? It's a pretty technical argument about how fast the shots were and whether it was a result of the door slamming or him intentionally firing through the screen door. He came up for parole in 2007 after 28 years. He was rejected for parole 12 times. And the daughter of the victim says it's not long enough. And of course, the argument was that he's earned his GED and been other rehabilitative programs, and that his 28 years in prison are 7 years beyond the average sentence served by life in prison. Life with parole was not available at the time that he was originally resentenced, since I lost before the United States Supreme Court. So he's still a life sentence without parole. One of the things that is humorous, but it's really true, is you have to believe in your case. And nothing was any more difficult for me to do than the next case that I argued in the United States Supreme Court in trying to believe in your case. One of my Attorney General bosses, told me that that's one of the most important things, that you have to act if you believe in your case, whether you do or not. Amedeo v. Kemp was, again, whether there was a jury challenge that was defaulted or not. But the difficult thing about Amedeo was the fact that this was where an allegation was made that the prosecutor and the judge got together and tampered with the jury. They were trying to make it look like it was representative as to African Americans, but they didn't want it to be truly representative. So what they did was they kind of picked and chose some local African American people that they knew to put on the jury to make it look like it was a fair cross-section. What happened, though, is they put it on a little piece of paper about like this size, and that was put in the clerk's office. So it wasn't like, "Dear Judge, I think we should tamper with the jury." It was some raw numbers that they ultimately found during post-conviction proceedings that showed the jury tampering. So here I go to argue before the United States Supreme Court that we like jury tampering in Georgia. But of course, the real issue was whether it had been defaulted because there wasn't a timely challenge. Justice Stevens asked me a question in the argument in this case that was really interesting. He said, "I know that you're saying that it's defaulted, and I know that you're saying that the piece of paper that they found in the clerk's office doesn't say what they say it says. But if it were true, and if it were not defaulted, it would be a very serious allegation, wouldn't it?" And you could have heard a pin drop in the courtroom, and I thought, you know, in that nanosecond before you answer, I thought, what exactly do they think I'm going to say? I said, well, of course, it would be very serious if they had proven it and if it weren't defaulted, both of which are the only things I had to say. I lost 9-zip, as you can imagine, but I thought that I did the best in any oral argument I've ever done was in the Amedeo case. But I did lose. They found that they had tampered and it wasn't waived. Now, in Tony Amedeo case, we had you think of such highbrow questions that you're asked for the United States Supreme Court, and this is what was asked of Steve Bright, who was representing Tony Amedeo. He was telling him that he was sentenced to death in Putnam County, Georgia, and I think this was Justice Stevens again, I believe. He said, "Where is Putnam County?" Mr. Bright said, "It's not far from Macon, more or less south." Mr. Bright, "More in the central part of the state?" And the question, "Below the gnat line," that's supposed to be G-N-A-T, gnats as in that kind of gnat. And he says, "Right about the gnat line." So here we are, the first question the United States Supreme Court is getting asked about the gnat line in Georgia. And of course, the gnat line is, some of you may know, is an imaginary line across Georgia below which there are gnats that drive you crazy in the summertime and above which there are no gnats. So I guess that Justice Stevens was trying to show his esoteric knowledge of Georgia trivia, and he was asking Steve Bright about the gnat line. And then, of course, they couldn't stand it. They decided to make a little humor at my expense, and so I was telling them that the disparities that resulted were fairly minimal. And they said that was like being just a little bit pregnant, and the whole courtroom went bonkers. And I was asked 102 questions in 20 minutes. That's probably the most, close to the most I've ever been asked in one argument. Fant versus Moore, this is abusing the writ. Here again, I look like the gypsy fortune teller here in this picture against Jack Boger of the NAACP Legal Defense Fund. And this is abuse of the writ. How many times? In Georgia, the fastest we've ever had anybody go through the 12-step post-conviction process is 6 years. The average time in all the big death penalty cases is about 10 years, but usually it's much more than that. And so one of the things that we were talking about in Zant versus Moore was how to prohibit abuse of the writ while still maintaining the availability of the writ for those with legitimate issues. And nobody understood what they decided. Interestingly, about ONeal More, he pled guilty and got the death sentence. He killed this older man, Frederick Stapleton, during a burglary in a place outside Augusta, Georgia. And he's the only death row inmate that I've ever had who asked to speak to me during the litigation and told me he wanted me to understand that he didn't hold it against me personally, that I was trying to execute him. And when he got out, he is a born-again Christian. Some of you have probably seen him on television. He's college educated now. He went back and finished college, and so he got a stay of execution. And Jesse Jackson and Andrew Young and the trial judge who originally sentenced him to death, they went before the State Board of Pardons and Paroles, and as a result, his death sentence was commuted to life. And now he's a minister. Felker, of course, is one of the premier decisions on the Anti-Terrorism and Effective Death Penalty Act. It was enacted under President Clinton, signed into law, and it was right after the term of court had ended. And so a Georgia case, Felker was the first case available to go forward to the United States Supreme Court, and they'd already finished their term, and so they took it on a quick expedited schedule, and we argued it. And so I was saying again, no pressure, because I love this. The ruling could ultimately affect Congress's power to say what sorts of cases the Supreme Court hears. So it's, kind of small little issues like that I'm arguing. Again, my mother said, okay, what are you arguing? Are you arguing abuse of the writ again this time? I said, no. This time I'm arguing that the Supreme Court should give up some of its power. It's a very popular position to take. And Felker, they claimed, was innocent. They got some DNA testing done through the newspaper, and the radio station got access to some of the evidence after he was executed and to perform some DNA testing. Big letters before the tests were done about this will exonerate Ellis Wayne Felker, and little bitty letters after the DNA testing was done saying that, of course, it connected him to the crime. So this is an interesting case because the DNA testing was done after he was executed in the hopes that he would be proven innocent and exonerated. In such a big case, they were hoping that it would be in Felker. Again, don't you love it? This is like an expedited hearing the same way they had with Richard Nixon. And this is a picture I found that was actually an artist's drawing of Justice Ginsburg. She actually went to sleep during an argument before the court. She actually put her head down and snored. And so I thought that might be what she would have done if she had to take an expedited hearing. But it wasn't in Felker, but she actually did put her head down. The 9 justices will emerge, take their seats, begin a rare special hearing in a case that goes to the heart of an individual's right not to be wrongly imprisoned. Again, no pressure, just the first case under the statute and affecting the Supreme Court rights. And they quote me. It's a nice quote for once. The only way to preserve the integrity of the writ of habeas corpus is to protect it from abuse. That's the back door of the court. That's where they made me go in, I'm sure. Well, okay. Don't you love this press? When you get back to the office and this is what's on your desk as a result of your high court grills, state lawyers. Again, that wonderful picture of me next to a picture of Mr. Felker. And this, of course, is one of the two famous spiral staircases in the United States Supreme Court. And I felt like I had been grilled. I was telling Sarah last night that it started off really badly. The first thing that happened in the United States Supreme Court is they make you spell your name phonetically so the Chief Justice does not mispronounce your name. And I'd been up there before, and of course I did the same thing again. And he said to me, Chief Justice Rehnquist said, General Boleyn. And then when I got up there, he said, or is it Boleyn? And I thought, does he think I'm going to correct him? I mean, I'm not going to correct what he says. And then I started out with my first part of my argument, and he decided he was going to make sport of me because his first question to me was, General Boleyn, have you ever heard of a little case called Marbury versus Madison? Could you give the facts of that case to this court? So it went downhill from there. We started with Marbury versus Madison, and it was a really difficult. At one point, I was being the ping pong ball, like, like this one, and back forth, trying to kind of like keep eye contact with all the justices like you're taught to do. And I was saying last night, too, that they kept asking me the same thing in different ways, hoping I'd give them a different answer, but I didn't. And I shared time with the Solicitor General, and one of the main things was they didn't want to hear anything about the death penalty. They wanted to make it a Marbury versus Madison argument, and so they were also, as they're wont to do, fighting with each other about what it meant. And so then I got a little bit better press. 4 justices, and those were the 4, grill a state attorney. That's a picture of what I probably look like. That's not really me. On a federal law designed to limit some appeals. And then here's my good press. Maintained her composure and doggedly stuck to her point that Congress intended to cut off that route of appeals for death row inmates. So, I was like Susan One Note. It's the same thing. Yes, they intended to cut off. Yes, they did. They intended to cut our ability to look. Yes, they did. Yes, that would be yes. What part of yes didn't you understand the first time? So at least I stood up to them. And of course, I won 9-0. So here I had this horrible oral argument, and I won 9-0. And then I had the good oral argument at Amedeo, and I lost 9-0. So that just goes to show you. He was sentenced to die. As I said, he claims new evidence would clear him, but his second petition was rejected a week after the law took effect. And then, as I said, he was executed and they did the DNA. Got a little bit ahead of myself. Now, I love tennis. And one of the things that I've learned is you're only as good as your last performance. And so every time I go into court, I realize that it's a new case, it's a new court. It's maybe justices that haven't seen me before, or if they saw me before and it wasn't a good experience, I'm going to see if I can make it a better experience this time. So I feel like that I get better all the time, and I feel like that I'm a much better lawyer now, and hopefully my last performance will be even better than the one before. I ran across this quote from Sandra Day OConnor that I love. I don't know there are any shortcuts to doing a good job. I know many of you are very, very smart, and I never think of myself as being so smart, but I know I'm a really hard worker. And I don't know any other way than just to get in there and know the whole record and do the best I can do. And then this is a quote from one of the current justices. I believe it's Justice Ginsburg. She said that they need to say what they want their lifestyle to be like and what they want a typical day to be like. Well, I can assure you, when I was in law school, I never thought that I would be sparring in the United States Supreme Court. So I hope that you'll think outside the box, and I'm sure you will much more so than I did in law school. And then I love this quote from Shakespeare. Do as adversaries do in law, strive mightily, but eat and drink as friends. I think in the death penalty arena sometimes we associate each other with either being pro-death penalty or anti-death penalty, and so sometimes it's difficult for us to be professional friends in the way that it's often possible in other legal arenas, but we try to be friends as well as adversaries. Thank you very much. Can you tell me if we got time for questions? Are there any questions? We got time for any before y'all have to go to your next class? Yes.
I'm just curious if you went directly from law school into public service, or if you spent any time in private practice, and if you did or if you didn't, if you think that's valuable or not valuable.
I clerked for a judge for about 4 months before I came to the law department. I think a lot of people like to have both experiences. Of course, like now, once I got in here and I was given these awesome responsibilities, I don't know if I could go in private practice and go backwards. So if I would have done it, I probably would have wanted to do, private practice first. There's 5 of us that do death penalty cases at the law department now. We're all women. And so we said the guys just couldn't cut it. Sorry. No, that's not true. And it's, again, I quote my mother, but when I was thinking about getting another job, she said, what would you ever do that's this interesting? I said, nothing. Absolutely nothing. I can't imagine. I like the writing part much more so than the oral arguments. Like I say, I consider myself a constitutional lawyer, so I didn't know if I'd want to write responses to motions for summary judgment or not. I just didn't know if that's, like I said, if I imagine my day, I don't think I could imagine it quite like that. So, anybody else? Sure.
I didn't notice in your slides that you stated there were any exonerations in Georgia for DNA, via DNA.
In death penalty case, in death penalty.
Cases. Has that been the case, and if so, is that giving you pause professionally as to what you're doing and certain doubts?
I think the Death Penalty Information Center lists 5 exonerations in Georgia, but those 5, I've gone through each of those. None of them were my cases, and not to say that that means anything except to say that I wasn't involved in those cases, but I've read the facts, and most of those in which it was a reversal of their conviction and decision for various reasons not to retry them. So that doesn't fit my definition of exoneration, although it fits a lot of people's definition. So the 5 that are listed on the Death Penalty Information Center's innocence list from Georgia predate me, so that's a long time ago, I guess. And the ones, we have about 118, 119 people on death row now in Georgia. And all I can speak to is the ones that I have seen, we've had very few cases in which there was question about identity. Now, a question about whether the death penalty should be imposed, yes. But with Felker, that was one of our few in which there was a real question about whether he had done it. He claimed he wasn't there, and there was not enough to take place. And so I just haven't seen really identity being a big issue. It's not so much that I'm defensive about exoneration, but of course I would be very concerned if I didn't think the right person had been convicted for the crime. That would give me great pause, and I do scrutinize the evidence very carefully. The way that I really can have an impact is hopefully I've gotten some credibility with the local prosecutors now, so they'll call me and they'll ask me, well, do you think this is a death penalty case, or do you think we have enough evidence? So hopefully I get to be in on the part of the process when it gets decided about what kind of case it is, rather than worrying in the long run about whether I'm executing somebody innocent. So yes, I would be very concerned if I felt like there was a question about that. And that's not been my experience, but I know that's not true for everybody.
As soon as you started law department, have you done appellate work for your whole?
Yes, I went, unlike you guys now, they recruit y'all to do things, but we just got put somewhere and got to do that. And so I did civil rights. I did civil rights jury trials, and I did extradition. I extradited J.B. Stoner back to Alabama for the murder of the children at the church. I did larceny of a cow statute. I did the opprobrious word statute because somebody called the East Point police chief a Nazi faggot pig, and that was whether that was fighting words under Georgia's opprobrious word statute. So it hasn't all been before the United States Supreme Court, but it's all been either constitutional or appellate litigation, except for my civil rights jury trials. I did some of those. The elevator operator in Georgia's biggest prison got tuberculosis, and so we had a big lawsuit, and so I did that. And then there was a death row escape of various 6 inmates off death row escaped, and Troy Leon Gregg, that's Gregg versus Georgia, he was killed by his fellow escapees. So that's how he died, and I litigated the case involving the prison guards who fell asleep so that they were allowed to do just like in the movies and tie the sheets together and come right down the front wall and get in the car and leave. So that's my other big jury trial was involving the guards who allowed the death row escape. So I guess even that was death row related. Yeah.
What was the percentage of that you gave about Georgia citizens who were in favor of like keeping the electrocution, like
It's something like 82 in the 80s
that were, and what was it? Percentage of Georgia citizens that what?
in favor of keeping the electric chair.
So there's like a less than 10% group of citizens that are against the death penalty altogether in Georgia, probably. Like,
Probably.
really?
I would think that's true.
Okay.
And interestingly enough, they say that a lot of jurors think that life without parole is more cruel than death. And so, you think that the imposition of a lot of life without parole sentences means that people are getting a little bit more easy on criminals, if you want to, but everybody tells us that they think they ought to be able to sit there and think about what they did rather than be executed. So I think that's an interesting phenomenon. I wouldn't have thought of that. Sure.
Do you know anything or have any opinions on the new research that's coming out about the lethal injection actually making you feel like you're burning up for 10 minutes without being able to move? Is that really any more humane than the electric chair?
Well, I think, first of all, you got to understand the development of the law when you went to, in Texas, they used to have the gas chamber, and they put the rabbit in there to see if the rabbit died before they had a lethal amount of jet. And they got so many letters in favor of the rabbit that the rabbit wasn't guilty. The rabbit was innocent, And so why did the rabbit have to die? Animal rights people are really crazy, And so, so I say that to say that you kind of got to look at it in the context of the development of methods of execution. So you have to, everybody said, well, even the anti-death penalty people said lethal injection is the way to go, that's the easiest thing. And even the recent challenges haven't really attached that 3-drug protocol. I think it's more, please forgive this expression, but it's more like it's overkill because you're trying to make sure the person is unconscious. So the main thing is, if the first injection produces unconsciousness and therefore lack of pain, if people can be convinced of that, I think that's what the key is. The other two, are part of we call it the 3-drug protocol, but the question is whether they're necessary. And I think what's been the big challenge is the people that are administering the injection. I judged a moot court competition here about the participation of medical professionals, nurses, and doctors in the lethal injection process. And of course, some of the problem is, you don't ever want the doctor to give you injection if you're a person in the real world. Do you want the nurse? The nurse is a much better person to give an injection than a doctor. So I think that it's been the administration of the 3-drug protocol that's been the big focus, more so than the drugs themselves. And of course, the Veterinary Association coming out, the paralyzing effect of some of those protocols, it has been called into question.
Have you ever attended any executions, and if so, did it change the way you look at the issue at all?
We have an open line to the prison. Usually I'm the person still litigating up to the last minute because, of course, they're going to file constant requests for stay of execution. So I can hear things like the prisoners being brought from the cell to the execution chamber. I can hear those things. I can hear the last words. I can hear the prayer, if they ask for a prayer. I can hear those. I can hear the first injections being given. They'll say those things. And so it's very sad. It's very sad. It's personally sad because the victim's family's hurting, the defendant's family's hurting. I'm not going to tell you which jurisdiction I know that has death pizza after they have an execution, but let me just assure you it's not me. I don't feel that way about it at all. It's hard professionally because you want to win and you want to beat the other lawyers. But, it's really hard to say that, if you win, the person's executed. So what I really try to see my role, and maybe that's just my way of dealing with it, is to making the case be final, whatever that is, whether it's resentenced, whether it's execution, whatever, is to just put an end to the countless steps of litigation. But yes, it does impact you when someone dies. And because I've probably been part of their life for a very long time, and they've been a part of mine. When my husband died, I got a lot of sympathy cards from death row, a lot. And it's very gut-wrenching. The attorney generals, I work for 3, and each one that we've had has gone to the executions under the theory that if we have them, that they need to be there. Because I tell you what, though, to me, the lethal injection, it seems more sinister to me than electric chair. I know that sounds really horrible because the electric chair does look very barbaric, but it's just kind of somebody on the gurney is just really, it's a very difficult thing to go through. So no, I have not been, but I feel like I'm there. And I'm very invested in the case and the person. So that would bother me if I thought it was someone who was not guilty of the crime. The only one I've ever really had a question about was 2 people who killed a man at a convenience store on Father's Day, and they each said the other one did it, and I wasn't sure that one of them did anything but stand there. But of course, he's still guilty under accomplice liability. But it bothered me that I just wasn't real sure that the truth was ever known about exactly how it went down. But they were both there, so we know that. So, anybody else?
You mentioned that during the Amedeo case, you didn't personally, or you personally felt that there was jury tampering, but you had to argue it anyway. Are there a number of instances where you have to argue a certain situation which you might not personally believe?
Well, I think that, there's always an argument I can get behind, but it's when something's so egregious and you're standing on a waiver principle, that's a little bit hard to take. To say that it shouldn't even get litigated, that's really hard to take. But a lot of times, it's just very interesting to get in there and be litigating the constitutionality of it, even if you lose. I mean, that's just kind of heady stuff to be dealing with that. But I don't really have, every day, I don't want to mislead anybody, every day is not like, gee, I don't know if I can really argue this. I mean, there's just very few instances in which that's been the case. There was one case in which, when you appeal from a 3-judge panel in a death penalty case in the 11th Circuit to the full court, you have to personally certify that you see a question of fundamental importance for the whole court, and I didn't see one. And so I had to go to the boss and I said, I'm sorry, I have to sign, Susan Boleyn, find that there's an issue, and I couldn't find it. He said, find it. I said, I can't find one. So he said, find one. And so I did find one, and we ultimately got it heard by the court, which is the only thing we were looking to do. So I think the case needs to be heard, the issues need to be resolved, and I pride myself very much in being candid with the court, not in terms of concessions, but in terms of if there's a weakness in the record, if the record doesn't show this, or if there's a weakness in a finding, then I'm very quick to say that's true. It's not there. Or it would have been better if we'd done this. And so I hope that I've built some credibility by being honest with the court in terms of litigating any of the issues. Yes?
Several other states like Florida and Texas execute a fair number of people as well.
Oh, yeah.
How has the litigation there affected your state, and how has your state's litigation affected theirs?
Well, in Texas, I asked them, I said, how do y'all execute people so much faster than we do? And they said, well, that's because everybody in Texas is in favor of the death penalty, including the judges. They said that's really the difference, is that everybody's really in favor. But they also have a direct appeal and a habeas corpus. It's called the unified appeal. We have a unified appeal, but it's not the same as theirs. So they have a few less steps than we do. But yes, everything that happens, capital litigation issues are like cute shoes. They're kind of going like this. Everybody raises the same issue, like everybody now raises the lethal injection challenges. And so we're all impacted by what happens in other states because, of course, the justices in the Georgia Supreme Court don't want to be behind the times. They want to be aware of what other justices are doing. So it's very, it's a legal specialty, but everybody kind of knows what's going on in other places. In Utah, they still have hanging. And one of the things they said that's based on a religious belief that Mormons say that by him who sheds blood, by him blood should be shed. And so that's a choice that Mormons are making to continue to have hanging. So I think the difference in our statutes has become a little bit concerning in terms of law impacting other things because our statute's so different than other statutes. But yes, we're all impacted by Florida and Texas. And that's why, of course, they go after Georgia and Florida and Texas because we're the death belt, so to speak. They talk about that. So, of course, they want to go after our cases because they think we're more vulnerable to challenge. Anybody else? Thank y'all very much.
I was just curious, kind of taking into account this quote that you gave, "May justice be done, though the heavens may fall," and bringing back to the Amedeo case, and this notion of even though this kind of acceptance on your part that there was really, really severe jury tampering here, and yet your office decided to pursue this case all the way to the Supreme Court, and what kind of dialogue takes place in your office, and deciding to pursue something that maybe, that on its merits clearly was incorrect, and it would almost seem like a political decision that you have to kind of blindly pursue the death
Right.
penalty instead of maybe take the tact of choosing justice, though there may be this political outcome that could be unsavory.
Well, it's a really good point. The only problem is we didn't take it. The lower court said that it was waived, and under the theory that the memo, the piece of paper, was always public record. It was always in the clerk's office. So it was always available. No, there wasn't any subterfuge it's just that till they got capital litigation specialists, they didn't realize what it was they had when they had it. So part of the thing was that we're not looking at it as litigating politically, but we're also not looking at litigating only the substantive aspect of a case. Because I always talk about it matters how you lose. Because, if there's a procedural default, if there's a waiver, if there are timely issues, if there's timeliness questions, that those procedural things are just as important as the substantive things. And so, of course, what happens in Amedeo sets the precedent for other cases. So it's not always like, let's just waste everybody's time and go where we know there's been an injustice. The principle of whether that was waived or not is an important principle. And of course, I'm kind of proud of the fact that's really what that case became is the clearly erroneous rule, that's a clearly erroneous case. So the principles were important. I think it matters if you lose I didn't try to hide that was a terrible allegation. I tried to say I don't think that they have proven that it is as, gross as you say it was, and also that it was a matter of public record. So we won in the lower court on the waiver, so they took it up. So we didn't really have a choice as to whether, and we do make those decisions about whether something is worth appealing. The only thing that usually happens, though, is you feel like that if the jury imposed the death sentence, our job is to try to enforce the jury's decision. The decision about whether the person's already got the death penalty has already been made. So you have a lot of factors, not just whether you're worried about my being uncomfortable about a jury tampering allegation. It kind of pales in comparison to these bigger issues of what about timeliness? How soon do you have to, how long are you going to let somebody wait until they raise an allegation, even a serious one? And are we going to, as the United States Supreme Court, tell the lower courts how to handle? So a lot of times, even in a horrible fact situation, you get a wonderful procedural principle or you get some guidance given to these other courts. So it's not always, so clear cut as to what can be accomplished if you appeal. But we didn't appeal that one. That cert was granted very quickly, I might add, in that case. Anybody else? Thank y'all very much.